Please welcome Mark Dreyfus.
Thanks very much, Sarah. And could I start by acknowledging the Wurundjeri people of the Kulin Nation, the traditional owners of the land on which we meet, and pay my respects to their elders past and present. Today I want to speak about the history and current practice of Australia's pursuit of human rights in the context of our nation's broader engagement with international law and institutions. I'll be arguing that because the pursuit of human rights involves the constant and delicate balancing of what are at times competing policy objectives, it's essential that the pursuit of human rights occur in the context of an open, constructive and honest debate between nations in the international sphere and between governments, civil society and the wider public in the domestic sphere. But before I get into the details of my speech, I want to reminisce briefly about the late Ron Castan, a friend and role model for me, a man whose influence on human rights in our country has been both deep and lasting. I think it's important that those of us who are involved in public life remember the legacy of those who've made lasting contributions to the lives of individuals and communities, and in the case of a figure like Ron, to our nation's history. Ron is perhaps best known for his work fighting for justice for Indigenous Australians, particularly for his advocacy in the historic Mabo case in the High Court. I don't mean in any sense to diminish the work that Ron did, an immense body of work over his life on all manner of human rights issues, but I think it's fair to say that he is best known for that work on the Mabo case. In working with Eddie Mabo to overturn the offensive legal fiction of terra nullius, Ron sought to redress a deep injustice, as old as European settlement in this country, and to set in place the legal foundations on which our current native title system has been built. It's interesting to note that unlike in the United States, where seminal Supreme Court case names like Miranda, Roe and Wade, Brown and the Board of Education form part of the political lexicon, people in the community talk about those cases, few Australians would know the names of even the most significant High Court cases. Mabo is a welcome exception to this tendency, the name now most closely associated with the idea of justice. I think that Ron must share the credit for this not only with Eddie Mabo and the other plaintiffs and counsel, but also with the writers of the castle. I'm sure that there are few lawyers who have not secretly daydreamed about finishing a case with the immortal words of Dennis Denuto, who, in summing up the grounds for his constitutional challenge to compulsory acquisition, declared to the court, and I quote, "It's the Constitution, it's Mabo, it's justice, it's law, it's the vibe." In our case against Japan's so-called scientific whaling programs at The Hague earlier this month, our legal team did briefly consider whether a reference to the vibe might usefully diffuse some of the tension in the court. However, with Professor Hilary Charlesworth being the only Australian judge out of 16 judges on the court, we somewhat regretfully decided against it. The second Mabo case is particularly significant in the context of this address because it is a clear example of international human rights laws positively influencing Australia's domestic legal system. Can I just ask, how are we going in terms of hearing me with the noise? I can lift the level, and I apologise for having drawn a bit of noise with me today. So would you like me to, can the people at the back hear me? Okay. The second Mabo case is particularly significant in the context of this address because it's a clear example of international human rights laws positively influencing Australia's domestic legal system. In his judgment in the case, Justice Brennan said this: "The common law does not necessarily conform with international law but international law is a legitimate and important influence on the development of the common law, especially when international law declares the existence of universal rights. Notwithstanding the historic nature of the High Court's ruling in Mabo, the outcome did not end the debate on native title in our nation. The Keating government's native title laws that were essential in transforming the High Court's ruling into a national system were themselves the subject of another fierce struggle, this time in the sphere of public policy. Many who engaged in that debate were genuinely seeking to develop a policy that would fairly balance the newly recognised rights of Indigenous Australians with the rights of other Australians. However, I'm sure that many of you would remember that some Conservative opponents of native title at that time engaged in a fear-mongering political campaign of the most dishonest and, I'm sad to say, now familiar kind. But we did have the debate, and notwithstanding attempts by some to derail the native title reforms with fear and disinformation, the situation for Indigenous Australians has been significantly improved as a consequence of the historic reforms that we as a democratic nation argued and ultimately accepted. Of course, I am well aware that despite these historic reforms, the fight for Indigenous justice continues, with huge and ongoing challenges in health, in education, and the complex and often fraught relationships between our first Australians and the justice system itself. And despite amendments to our Constitution in 1967 that removed the prohibition on counting Indigenous Australians in the census, many would say that the silence of the Australian Constitution regarding first Australians remains an injustice that needs correcting. It is my intention that Australia continue to honour and build on Ron Castan's legacy of Indigenous justice. In this regard, I firmly believe that constitutional recognition of Aboriginal and Torres Strait Islander peoples is an important measure that we should pursue. It would strengthen our Constitution as a unifying document by properly extending the recognition of our first Australians beyond the common law and legislation into the legal bedrock of our nation. Our Constitution should be a living document. Of course, it reflects the times in which it was drafted, but to remain relevant and respected, our Constitution should also reflect the fundamental shifts that have occurred in our society in over a century since Federation and that have made us a more modern, progressive and unified nation. The framers of Australia's constitutional arrangements could scarcely have imagined the developments that have occurred within our nation and also in the international community since World War II. In the aftermath of the Second World War, Australia became deeply involved in forging a new international system and in the development of human rights law that occurred under the United Nations framework. It was the Labor Party's Doc Evatt who chaired the United Nations General Assembly when it adopted the Genocide Convention and the Universal Declaration of Human Rights. Not only that, but Australia was one of 8 nations to draft that central human rights document. Since that time, international human rights law has grown in both scope and sophistication. The 2 UN covenants, which were adopted by the United Nations General Assembly in 1966, the first on civil and political rights, the second on social, economic and cultural rights, have been particularly significant. These developments in international law reflect a change in the status of human rights principles, which are now increasingly considered as binding between states. It is no longer assumed that states can do as they please within their jurisdictions and escape international scrutiny based on the once paramount doctrine of non-interference in the internal affairs of UN member states. Developments in international human rights law during the 1960s and 1970s coincided with changes within Australia, including the end of the White Australia policy, reforms to address racial discrimination against Indigenous Australians, and domestic measures here in Australia to oppose apartheid in South Africa. In 1966, Australia signed up to the Convention on the Elimination of All Forms of Racial Discrimination, and Australia was one of the first countries to sign the 1979 Convention on the Elimination of All Forms of Discrimination against Women. Gough Whitlam's government was central and enormously energetic in efforts to bring Australia into the modern era of human rights. As Prime Minister, Whitlam was committed to Australia's engagement in multilateral institutions, and he and Lionel Murphy were responsible for driving the introduction of federal protections against racial discrimination. Indeed, in giving the Lionel Murphy Memorial Lecture earlier this year, I was humbled to be reminded of the remarkable range of reforms that Lionel Murphy instituted in just 3 years as Attorney General. His first act was to abolish the death penalty. Within a year, he had introduced a national system of legal aid, an institution that quickly became pivotal in providing justice for the disadvantaged in our nation, and which celebrated its 40th anniversary just yesterday. Murphy also established the Law Reform Commission and the Institute of Criminology and proposed the establishment of a General Federal Court. He also found time to introduce national trade practices legislation, and he was instrumental in modernising family law in this country as the driving force behind the Family Law Act 1975. I also acknowledge that Malcolm Fraser's government demonstrated respect for our international obligations by increasing Australia's refugee intake, particularly from Asia, and working to oppose apartheid in South Africa. Australia's active engagement in international human rights continued throughout most of the 1980s and 1990s. One notable example of the growing linkages between international and domestic human rights standards occurred following Australia's ratification of the optional protocol to the International Covenant on Civil and Political Rights, when a Tasmanian by the name of Mr. Nicholas Toonen brought a complaint to the United Nations Human Rights Committee against laws criminalising homosexuality in his state. In the landmark decision of Toonen and Australia in 1994, the committee found that adult consensual sexual activity in private is covered by the concept of privacy, and that Mr. Toonen was affected by the continued existence of the Tasmanian laws which continually and directly interfered with his privacy despite their lack of recent enforcement. In response to the recommendations of the Human Rights Committee, the Keating government passed an act effectively voiding the Tasmanian legislation. I'd have to say there's something of a design flaw in the edge, and it's caused by there being a lot of glass, I think, but I'm going to keep battling on.
I gather the sound is better there.
I think the sound's better where you are than where I am, which is the problem. Throughout the 1990s, the Australian government worked hard for the establishment of the International Criminal Court. And some of you will remember that with the court's statute finally agreed at an international level, John Howard then wavered at the point of Australia's ratification. Once again, a fierce domestic debate erupted as many within the party, particularly Bronwyn Bishop, opposed ratification. I expect that some of you were also part of that debate, though probably not in Ms Bishop's corner. Fortunately for Australia's international reputation, wiser heads prevailed, and in 2002 Australia ratified the statute of the International Court that it had fought so hard to establish. In bringing perpetrators of human rights atrocities to account, the International Criminal Court has played an important role in upholding human rights standards and strengthening the international rule of law. And I had occasion just 3 weeks ago when I was in The Hague arguing the whaling case to speak with some of the judges of the International Criminal Court and hear firsthand from them how its work is going, it's work that Australia continues to support in the form of funding. In order to have a productive dialogue about human rights and to effect meaningful change, it's important that nations listen respectively respectfully and engage constructively with the views expressed by others in the international community. Although Australia was closely involved in East Timor's independence struggle in 1999 and was active in the suspension of Zimbabwe from the Commonwealth in 2002, under John Howard's government, Australia started to withdraw from its traditionally constructive approach to multilateralism and became notably less open to constructive criticism from international institutions. UN special rapporteurs were made to feel unwelcome. Australia became antagonistic towards international human rights committees, and many non-government organisations involved in upholding the international rule of law and holding governments to account were treated with disdain. Indeed, within Australia, attempts were made to gag non-government organisations that were critical of the federal government. For example, in 2006, the Australian Tax Office revoked the charitable tax status of an NGO called AidWatch on the basis that it was engaged in advocacy for a more efficient and effective use of Australia's foreign aid. And this advocacy was not a proper charitable purpose. The effect of this decision not only threatened the funding base of AidWatch, but had a chilling effect on the freedom of political communication that throughout the charity sector, as organisations that had long advocated for policy changes were suddenly unwilling to speak out lest they have their funding base undermined by similar rulings. A 4-year legal battle followed, ultimately reaching the High Court in 2010, where I'm pleased to say that the High Court majority reversed the decision of the ATO by throwing out the narrow and archaic definition of charitable purposes that had been used to try to shut down criticism of the government. I've recently been speaking publicly about contemporary attempts by Conservative state governments to silence the voices of the institutions that constitute our civil society, with the governments of Queensland and New South Wales blatantly trying to prohibit what they define as political advocacy by independent organisations that they fund. I consider these attempts to prohibit political activities by independent legal and other community organisations to be inimical to the freedom of political communication that is a characteristic and strength of Australia's robust and open democracy. And that's why in extending joint funding arrangements for community legal services with the New South Wales Government this year, I refuse to accept the constraints on political activities that the New South Wales Government sought to impose. And that's why in May this year, our government passed the Not-for-Profit Sector Freedom to Advocate Bill, which came into operation in June. This is a law which prohibits and invalidates clauses in Commonwealth agreements that seek to limit or restrict not-for-profit entities from advocating on Commonwealth policy issues. I won't go into further detail on these matters here this morning, but the fact is that despite raising this unacceptable, anti-democratic behaviour several times in recent months, I've seen no indication of a change of policy from New South Wales or the Queensland Government, and no sign that the federal opposition would, should they win government, do any different than their Conservative state counterparts. Indeed, if Senator Brandis's comments are anything to go by, it appears as if the federal opposition would return to the policies of suppression of political advocacy by non-government organisations that the Howard government once pursued and that their Conservative state colleagues are now engaged in. As I said at the outset of my comments this morning, to engage constructively in the challenge of building a more just nation consistent with evolving standards of human rights, our nation needs to be able to construct an honest and constructive debate on the policies that are required. It is inevitable that reforms to better protect human rights will spark debate within communities, whether it is a community of citizens arguing about reforms to domestic law or the community of nations negotiating international treaties. That is as it should be. At the international level, the human rights regime is built upon dialogue amongst peers, and that is what our government has been engaged in. I'll give you some examples. The Australian Government has signed the optional protocol to the Convention Against Torture and other cruel, inhumane and degrading treatment or punishment, and we are now working with the states to make ratification a reality. Our government has acceded to the complaints mechanisms provided by optional protocols concerning women and people with disabilities, demonstrating our willingness to have our nation's standards and practices scrutinised. Our government has announced Australia's support for the Declaration on the Rights of Indigenous Peoples, and we expect that document to help guide Australia's domestic policy development. We are an active participant in the Universal Periodic Review process conducted by the UN Human Rights Council, and we have built our own National Human Rights Action Plan around the vast majority of recommendations of that review into Australia. These measures demonstrate our willingness as a nation to accept criticism and to engage constructively with ideas that are generated from international scrutiny of our country. It is an approach that we encourage other countries to adopt. And Australian candidates continue to be supported by our government for important international positions, as we believe that Australia should be actively engaged in deliberations amongst nations. For example, Ron McCallum is now the Vice Chair of the UN Committee on the Rights of Persons with Disabilities, and Megan Davis was recently reappointed to the UN Permanent Forum on Indigenous Issues. We are supporting the nomination to the International Court of Justice of Professor James Crawford, a superb lawyer with an excellent sense of humour who I just recently had the honour of appearing with in our case against Japan before the International Court. Our government has also supported the appointment in May 2013 of former High Court Judge Michael Kirby as Chair of the Commission of Inquiry into Human Rights Abuses in the Democratic People's Republic of Korea. Australia has also been active in negotiating and co-sponsoring numerous resolutions in the UN General Assembly and the UN Human Rights Committee across the breadth of thematic issues from the rights of people with disabilities to the global abolition of the death penalty. And finally, I'd note that with our sound multilateral record of achievement up until now, we have a solid basis to launch Australia's candidacy for the Human Rights Council 2018 to 20 term. This is the first time that Australia has sought membership of the Council and reflects our strong commitment to the promotion and protection of human rights. Our government has worked hard to re-engage Australia as an active and constructive participant in the international community. And we believe that we have a responsibility as a mature democracy, and particularly as a member of the UN Security Council, to continue to press ahead with the international human rights agenda. In addition to our positive international engagement in human rights, our government's legislative and programmatic record also demonstrates a constructive approach to promoting human rights within Australia. For example, the Parliament's proper role examining the compatibility of new and existing legislation within human rights standards has recently been formalised through the creation of a specific Parliamentary Joint Committee on Human Rights, and by the requirement introduced by Federal Labor in 2011 that bills and legislative instruments be accompanied by a statement of compatibility with human rights. This second measure requires that every time a minister proposes a law, he or she must be prepared to permanently place on the public record a statement detailing how the laws being proposed are compatible with Australia's obligations under 7 core human rights treaties. Our government has been working also to consolidate Australia's anti-discrimination laws which have a noble origin in international human rights treaties, but which now appear in 5 partially overlapping pieces of legislation and so have become complicated and confusing. The government is now working through the technical issues presented by the Senate Committee's recent report. And while this work of consolidation has been occurring, I am proud that our government has introduced and passed long overdue protections against discrimination on the grounds of sexual orientation, gender identity and intersex status. Now, I want to make some concluding comments and also talk about the government's policy arrangement that we've reached with Papua New Guinea. I'd rather that the people outside who have concerns about that were inside listening, but perhaps they can come in later. I have outlined some of the important work that's being undertaken by our government to further the international human rights agenda, and I've made some brief comments about the improvements to human rights protections that we've made in the domestic sphere. And I've been arguing today that the pursuit of improved human rights standards will inevitably generate debate. And it's my firm view that constructive debate, constructive criticism, is beneficial to policy development in both the international and domestic arenas, and that debate and criticism should be encouraged by governments, not crushed as dissent. So I encourage the people outside to engage in constructive debate. I'm not presently finding, as you're probably telling, at a physical level, I'm not presently finding their engagement in the debate all that constructive, but they, of course, are a case in point as to the passions that policy change often inspires. It's debate that's to be welcomed, but one would hope it's engaged in a constructive spirit. And I do want to take this opportunity to address the issue of our nation's asylum seeker policy that has once again gripped our national debate in the last week, and it's relevant to the themes that I've been discussing this morning. I do not want to even try to analyse every aspect of the issues at hand, but I do want to briefly give you my views about what I know is a vexed matter for all compassionate Australians, including probably everybody here today. I've no doubt that David Mann will have something to say about this when he addresses you this afternoon. For more than a decade, since political bipartisanship and measured debate on the issue of asylum seekers was, I would say, deliberately destroyed by the Howard government for its political advantage, the treatment of refugees coming to Australia has polarised our country. Last Friday, the Prime Minister announced a policy that has been designed to end the traffic in human suffering driven by people smugglers. The subsequent debate about the merits of this policy has been understandably fiery. Clearly, our government has taken a firm policy position, but the reality of recent years is that the situation has changed dramatically, and with that change, more than 1,000 people have drowned in the ocean trying to reach this country since 2000. More died yesterday when a boat sank in Indonesian waters. And this situation is unacceptable. I don't think that we can continue to pretend to ourselves that this appalling toll of deaths at sea will not continue to occur without a significant change in policy by the Australian government. The policy announced by the Prime Minister last Friday is aimed squarely at removing the incentive that induces the desperate to make the dangerous voyage to Australia. And with that incentive removed, the policy aims to fundamentally undermine the business of the smugglers who exploit the desperation of the people that they carry. Obviously, the decision to seek to close this route for those wanting to seek asylum in Australia was only taken after careful deliberation and years of debate in which many options were considered. I say again, the new status quo of ongoing and very likely increasing deaths at sea is intolerable, and all prior efforts to find policy measures that would stop the dangerous flow of boats have been unsuccessful. I'd also point out that the government will be implementing these new arrangements in a manner that is consistent with our international obligations. Papua New Guinea is a signatory to the UN Convention on Refugees, and it will remove its reservations to that convention for people covered by this arrangement. Asylum seekers found to be refugees would be settled in Papua New Guinea with appropriate support from the Papua New Guinea government. Those transferred and accommodated in Papua New Guinea will be treated with dignity and respect and in accordance with human rights standards. They will not be returned to their place of persecution, and the obligations of the Refugees Convention will be adhered to. There's another aspect to the moral imperative for this policy change, which is that our international legal obligations should not be seen through a parochial lens that seeks to confine our responsibilities to only what happens within our borders. The United Nations High Commission for Refugees has put in place processes to deal with the international issue of refugees, and the actions of people smugglers completely subverts that system. Australia cannot claim to be responsibly engaged with the international framework set up to deal with refugees if we are willing to tolerate the subversion of that framework by people smugglers who have created a dangerous and Hobbesian system, driven not by human rights obligations but by the pursuit of profit. There are thousands of refugees waiting in UN camps who do not get on boats, in some cases because they are so poor that such journeys are beyond contemplation. They are amongst the neediest of refugees awaiting their chance to come to Australia or some other safe country under our humanitarian program. And for every boat arrival that we now say no to receiving here, a place is made for a refugee who is patiently and desperately waiting for their chance in a UN camp. So let me be clear. Not one less refugee will be taken into Australia as a consequence of our arrangement with Papua New Guinea. And those that we do take in will be those who have been assessed through the processes established by the United Nations High Commission on Refugees. Which brings me to another important fact that is often lost in the current political noise. Our government has recently increased our humanitarian intake by 7,000, the largest increase in 30 years, so that Australia now accepts 20,000 refugees a year. Of the only 22 countries with a dedicated resettlement program under the Refugees Convention, our nation is now in the top 3 for refugee settlement, along with Canada and the United States. And our government will consider another increase to 27,000 refugees, which was the recommendation of the Houston panel, if there is now a significant decline in the deadly voyages by boat. The polarised, passionate and regrettably often disgracefully opportunistic nature of the debate about asylum seekers over the last decade has led many positions to become so entrenched that the important facts I've just outlined are often obscured. And consequently, the realities that we must responsibly confront with effective policy solutions have become harder to see. In this regard, the federal opposition have once again been engaged in reprehensibly irresponsible, dishonest and self-serving tactics motivated, it seems, by the sole purpose of furthering their partisan political interests. Of course, there should be a genuine debate about how best to respond to the immensely difficult challenges that Australia faces in this area. But the Liberal Party is entirely absent from that debate and are instead back to their old playbook of fear-mongering, trashing diplomatic protocols and throwing up 3-word slogans in place of considered policies, the latest of which is the risible and duplicitous Operation Sovereign Borders, a slogan clearly designed to once again dangerously conflate what are humanitarian and law enforcement issues with matters of national security. I will have more to say about these issues over the coming weeks. Indeed, I have been wrestling with these issues for my entire professional life, and I welcome constructive contributions from anyone, anywhere in the community, regarding this enormously difficult policy area and the questions that it raises. But I strongly believe that we can and must rebuild our confidence and pride in our nation's humanitarian programs, and I sincerely hope that we will find a way to build a lasting, bipartisan approach to these difficult issues that could become a symbol of our maturity as a nation. As I said when addressing the Sydney Institute last week, a robust, open and honest conversation between those with differing viewpoints creates the energy that drives a vibrant and creative democracy. Viewed through one eye, the world has no depth, but with the parallax created by differing viewpoints, we perceive the world and the challenges that we face in 3 dimensions, and our nation is made richer and wiser for that. Thank you very much.
I'm going to, as the chair, take the opportunity though to ask you a first one just about, you've talked a lot about compliance with international law, and when you were talking about the so-called PNG solution, you've mentioned the Refugee Convention. I was wondering about Australia's general compliance with the International Covenant on Civil and Political Rights. Mandatory detention many times, whether it be here, is a breach of that covenant, as you know. I'm certain it's a breach, therefore, when we send them to other countries. We've had allegations of, gross allegations this week of the way of things happening in Manus and Nauru, for which Australia is responsible. That's a breach of Article 7, torture and inhumane treatment. So I was just wondering if you could comment on the compliance. I might just make one more point about the ICCPR, and that is Australia's general compliance with optional protocol decisions. We complied with Tunin, as you mentioned, but there's quite a few that we have not complied with.
I think we're going to have to agree to differ on whether or not the arrangement that we've struck with Papua New Guinea complies with our international legal obligations. It's the government's view that it does. I would ask that people not refer to the arrangement we've come to with Papua New Guinea as the PNG solution, as Sarah just did. That is not the name that I would give it. It is not the name that the Prime Minister or any other minister has given it. It's illusory to label these policy measures, any policy measures in this area, as a solution, quite apart from the connotations that it evokes. And we see this as a part of long-term work that has to be done in our region, which means working with the countries that are part of our region. It's a bit like you don't always choose your neighbours. Well, we have to work in the part of the world that we are in, and we have to work with the countries in our region as we find them, with all of their imperfections and all of their goodness, depending on what particular position they're taking on particular issues. We work with Indonesia, we work with Papua New Guinea, we work with Malaysia, we work with Singapore, we work with Thailand, as we must. And I'm hopeful that things like the arrangement with Papua New Guinea, or the small arrangement that we've reached with Indonesia, announced last Friday as well, which is that Indonesia is, from the 20th of August, going to stop giving a visa on arrival to people arriving from Iran, which has caused part of the flow of refugees or people claiming asylum, because not all of them have proved to be refugees. We have to work with the countries in our region, and at present, our view is that we will be complying with our international legal obligations. Certainly that we will be complying with the Refugees Convention in transferring people who arrive in Australia to another country, in this case Papua New Guinea, which is a signatory to the Convention. I think that's a very important point to note, that it is a signatory to the Convention. We propose to support this country, which is a signatory to the Convention, in ensuring that it can comply as it wishes to do with its obligations under the Convention.
Okay, we've got one there. Yeah, we've got a roving mic.
Can I make a comment and then ask a question? The first comment is, in all honesty, I don't believe that the Papua New Guinea issue is going to stop the boats. And with that premise, can I make a proposal? And that is that more money is invested in Indonesia. And in that regard, I wonder why Australia is not trying to stop the boats by putting a lot of money into Indonesia in building institutions to process individuals promptly. That would immediately stop the people smuggling, because we would fly them over or provide them with non-leaky boats, proper boats. And we would welcome them here and we would get them here safely. And I think we need to alter entirely our approach to how we deal with asylum seekers. And we need to change the language that we're using. We shouldn't talk about queue jumpers. We shouldn't talk about asylum seekers. We should be talking about people who are fleeing anything similar to Nazi Germany and people who can contribute to this country.
Thank you for the comment. I think it's worth noting that, a bit as I said in my previous answer, we have to work with the countries in our region. We're not free to unilaterally impose on Indonesia something that we would wish to occur in Indonesia. We already support, and I'd accept your suggestion that we should be supporting more, but no one in this audience should think that we are not already supporting the work of the United Nations High Commission on Refugees in Indonesia. We are. And no one should think we are not supporting the work of IOM in Indonesia. We are doing that too. We are working very actively with Indonesia on the ways in which they can accommodate. In their view, they are a transit country. You've heard this before. They are not signatories to the Refugee Convention. They don't propose, as I understand it, anytime soon to become signatories to the Refugee Convention. So we have to work with them and all of the other non-signatory countries that lie between us and countries from which people are fleeing to see whether we can come to some better arrangement. I agree with you about language. You won't hear me using the word queue jumpers. I'm not sure about whether or not asylum seekers is or is not an appropriate term to use. I think it probably is, because that's the language that the Refugees Convention in part is based on. But again, I take your point. We need to remind ourselves all the time about the persecution that people are fleeing from, the conditions that they are leaving, which has prompted their flight. But it's not something we are going to be able to deal with in Australia by Australian action alone. It's a complete fallacy. Our opposition seems to be proceeding ludicrously on that basis at the moment, that it can just be unilateral Australian action. You've heard the condemnation using the word unilateral that's been given to various proposals from the opposition by the government of Indonesia. They say, do not engage in unilateral action. And I think that might give you some hint as to the level of difficulty that there is in engagement with Indonesia as a sovereign nation with whom we have very respectful and close relations. I hear suggestions, for example, that we should send in more police. We have Australian Federal Police that are working to assist Indonesian law enforcement authorities, but they have to be invited. It's not a matter of simply sending in police any more than it's a matter of sending hundreds or thousands of Australian officials or a great deal of money from Australia to work in refugee camps. We have to be invited. Indonesia's a sovereign country. We have to respect what they wish to do. So we are going to continue to work with Indonesia, just as we're going to continue to attempt to work with other countries in our region.
Okay, there's one in the stripy shirt. No, behind you, sorry. Yeah. We need a microphone.
Thank you. Hi, Mark Dreyfus. My question is based on the new policy with PNG as well as previous policy with Manus Island and Nauru. Given that it's based on deterrence, I was wondering what empirical evidence any deterring sort of oriented policy is based upon, and whether you believe that deterrence is actually a thing that is considered by asylum seekers before they board boats.
I don't think it's a matter of that you can ever have what you could describe as empirical evidence for. You can't really do polling surveys of people who are proposing to come to Australia. You can certainly ask questions of people once they arrive, and that's occurring when people arrive at Christmas Island. The officials of the Department of Immigration talk to them about what first of all prompted their decision to come, because that's part of the assessment process, but also what they were told by people smugglers who brought them in unseaworthy boats to Australia. And what we understand to be the position is, first of all, that people smugglers tell lies. They misrepresent Australian policy. They misrepresent everything about Australia. They misrepresent what is going to occur to people when they arrive. And what that tells us is that very often people seeking asylum in Australia are making a decision to travel on a false basis. We have no doubt that despite the clarity with which we have sought to send a message as to what will occur if you arrive by boat without a visa, that is, you will not be settled in Australia, that message is being blurred or misrepresented. The extraordinary statements that have been made by the opposition, sorry to be partisan, during the course of this week, along the lines of this won't work, or the Rudd government is incapable of delivering this program. That's all being used by people smugglers in Indonesia to say to people proposing to travel, the Rudd government's policy won't work. You can't empirically establish in advance, perhaps ever, what is the basis for deterring people from making this dangerous journey. But you can make an assumption that it is likely to have an effect on very many people if their goal, which is to settle in Australia, is not going to be achieved. They will receive refuge, but it won't be in Australia. Now, we'll find out. We didn't think that it was going to have an effect instantly. The Prime Minister and Tony Burke, as Immigration Minister, said this last Friday. We said that asylum seekers would continue to test the resolve of the Australian government. That's now occurring. We won't know for some time whether this new arrangement with Papua New Guinea is going to have an effect on the flow of people coming by boat.
Okay, what I think I'm going to take is 3 questions, and then
I'll try and give shorter answers.
Then we'll have to wrap it up. So this lady here. So please be brief in your questions and to the point. Then the man in the check shirt.
I would like to question and ask the government to take a good look at Iran. The question that these are all economic migrants suddenly seems to have appeared. I would just like to quote the case of an Iranian poet imprisoned for 5 years and his case taken up by Penn. I recently had a card from him saying, "I have been released from jail into the wider prison that is this land." I think people coming from Iran are very likely to be genuine refugees who are denied exactly the kind of freedom of speech that we claim is one of the fundamentals of fair and just government. So I would like to ask if you will look again at the question of the need to define Iranians as genuine refugees.
Okay.
Well, can I just make it clear? I do not say that everybody who is coming to Australia from Iran seeking asylum is not a genuine refugee or is, to use that term, an economic refugee. Very many people coming from Iran have been established to be refugees by Australia's processes. But equally, a quite substantial proportion, particularly of recent arrivals from Iran, have gone through all 3 levels of review that we have in Australia for the assessment. That's 2 levels of merits review and a judicial review, and have ended at the conclusion of that process, which takes many months, being found to be not refugees for the purposes of the Refugees Convention. They present a particular problem for us as a community because they are in detention as people who should be returned to their country. They are unwilling to be returned, and their government has adopted the formal position, with no little irony, that it is the human right of every Iranian to live wherever they wish in the world. And as a consequence, despite the support of the UNHCR on this matter, we are unable to return people who are thrice refused, that has been right through the process, to Iran. But don't take me to have ever said that every person coming from Iran is in any way an economic refugee, and in any sense do not take me to not understand the dreadful abuses of human rights that continue to occur on a daily basis in Iran and have been going on for many years.
I think we've only now got time for one, so it'll be the man with the microphone.
Hi, I just wanted to ask a slightly more personal question, if that's all right. I just wanted to know if and when your personal values might conflict with your role as Attorney General, how you reconcile them.
It's a good question, and it's one which faces every minister, possibly every member of Parliament. I take the view that I'm not here merely, this is the Burkean proposition, that I'm not here merely to reflect what I decipher as the wishes of my electorate. I'm here to bring to bear my own personal judgment, my moral foundations in every decision that I make. Equally, I accept as a Cabinet Minister that I am bound by Cabinet solidarity. I will not reveal what occurs in the Cabinet room, and once the decision is made by the government of which I am part, I will go out and explain to the best of my ability what those decisions of the government of which I am part are, why they were made. Rightly, you point to the fact that there would be a point for everybody in which your moral position or what your foundational beliefs are conflict with a decision that the government of which you're part has taken. At that point, which I have not reached in any of the decisions of which have been made while I've been a member of the Cabinet, I would resign, because that's what is required of you. And I haven't reached that point at this time. But certainly it's in my mind from time to time that that is the option that I have and every Cabinet Minister has, to resign if you've got a conflict, if you seriously cannot go out and defend a decision, whether or not whatever you had said in Cabinet.
Thanks.
Okay.
One more?
One more?
One more.
Okay, one more. I think the lady, you've got glasses, you're just there. I think you've had your hand up quite many times. Thank you.
Hi. Australia is a paradox of progressive policies juxtaposed with isolating conservative actions. We were once called the social laboratory, but now repealing the RDA, excising Australia's mainland, the current asylum seeker policy, funding cuts to human rights education. Why is it that we take one step forward and then 3 steps back?
That's an unanswerable question, I'd have to say. We're a democracy. We have debates. I think one of the reasons I thought it useful to talk about the history since the Second World War in the speech that I gave earlier was that I think we can look with some pride on the overall direction that we have taken, the journey we've been on, and the massively greater protection of human rights that we have in our country now than where we were at the end of the Second World War. The express consideration that governments have to give to human rights questions, I think overwhelmingly we can say we've made very substantial progress. Why we have steps backward from time to time is less clear to me, because for me personally, I think that struggling for human rights, continually trying to improve the human rights position in this country and throughout the world ought to be unarguable, but it is arguable, and that's because within these questions are different political imperatives. I'll end with one little example, which is the debate that we've had over, I shouldn't perhaps diminish it as a little example, it's the debate we've had over the removal of the exemptions in the sex discrimination legislation, in the anti-discrimination legislation, at the same time as introducing to Australian law in May of this year and having it pass through the Senate, an additional ground of discrimination dealing with sexual orientation, gender identity and intersex status. We also removed the exemption from the discrimination laws that apply in the aged care sector. And this is in a context where many people said, and the Senate committee commented on this, that we should also be removing the exemption that applies for other religious institutions, particularly schools. Now, you can all in this room understand the arguments that there are around that. It's said to be a clash between religious freedoms and human rights, freedom from discrimination. And resolving that is what we are going to do in coming years through the democratic processes that we have. What I've said as Attorney General is that I'm very pleased to have removed the exemption in the aged care sector, and that the government will not be acting precipitately. The government won't be acting to more generally remove the exemptions without deep and probably long consultation, because we're conscious of the issues that are raised. That's a mark of a civilised society, that we can have these debates, because there's values on both sides of the debate. And probably the short answer, I'm giving a long answer, but the short answer to your question about why we have steps backwards is that we have different sides in Australian politics, and I thought there was some regression in a human rights sense under the Howard government, because they took particular views, particularly in the international arena, but also more or less a complete failure to act in the domestic arena. That's the ebb and flow of politics in Australia.
Okay, thank you,
Sarah.
very much. And will you please join me in thanking the Honourable Attorney General Mark Dreyfus.